Ayes have it. Call on Government Order of the Day number 2.
Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill, first reading.
The Honourable Paul Goldsmith.
Mr Speaker, I move that the Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill be now read for a first time, and I nominate the Commerce Committee to consider the bill. This bill amends the Patent Act 2013 and includes measures to build on Australia-New Zealand closer economic relations. The Patents Act 2013 came into force on the 13th of September 2013 and was a significant step towards driving innovation in New Zealand. It replaced 60-year-old legislation and introduced a patent system in New Zealand that is tailored to the 21st century. Significantly, it also aligned our patent system more closely with that of Australia's. In doing so, it enables measures to be taken to build on Australia-New Zealand closer economic relations to further integrate Trans-Tasman regulation. Currently, most patent applications filed in New Zealand are also filed in Australia. Each application undergoes separate examination process in each country to determine whether the application relates to a patentable invention and therefore whether or not a patent should be granted. Importantly, each country examines its application to determine whether the invention claimed is new, involves an inventive step and is useful. This results in significant duplication, Mr Speaker, of effort and resources to perform essentially the same task. Part 1 of this bill provides for the implementation of a single patent examination process and a single examination process for Australia and New Zealand. Single, more efficient patent application and examination processes will remove duplication for both businesses and intellectual property offices of Australia and New Zealand. These processes have the potential to create significant savings for businesses and exporters needing professional advice and related services for obtaining patent protection. It will also make it easier for businesses to protect their inventions in both countries. A business will be able to prepare and file one patent application and pay one fee to either IP Australia or the Intellectual Property Office of New Zealand for granting a patent in Australia and New Zealand. The bill allows for IP Australia and the Intellectual Property Office of New Zealand to develop work-sharing arrangements for examination of patent applications. For example, it will enable patent applications for the same invention to be examined by a single examiner in either country. This will eliminate duplication of examination effort by IP Australia and IPONS. The process will, however, take account of differences in national patent laws and result in two separate and independent patents. Each patent would be tailored to the specific and individual laws of Australia and New Zealand. Part 2 of the bill, Mr Speaker, implements a single Trans-Tasman regulatory framework for Australian and New Zealand patent attorneys. Patent attorneys are a small profession providing specialist advice to businesses on the protection and exploitation of intellectual property rights. The regulation of New Zealand patent attorneys has remained essentially unchanged, Mr Speaker, for more than 60 years, and because of this, the framework falls well short of modern standards for occupational regulation. With the majority of Australian and New Zealand patent attorneys being registered to practice in both countries, a single regulatory framework will mean patent attorneys will be regulated under a modern occupational patent regulatory framework. It will save them time and cost because they're able to practice on both sides of the Tasman. It will break down barriers to patent attorneys offering their service on a Trans-Tasman basis, and it will encourage competition within the profession for the benefit of businesses who need their services. The bill seeks to implement the framework as set out in the arrangement between the Government of Australia and the Government of New Zealand relating to Trans-Tasman regulation of patent attorneys. The framework will include a single register of patent attorneys maintained by IP Australia, a Trans-Tasman IP Attorneys Board to administer the qualifications regime and investigate complaints about patent attorneys, and a Trans-Tasman IP Attorneys Disciplinary Tribunal to determine such complaints. The Government has worked closely with Australia to establish the framework, and I'm grateful to my Australian counterparts for their work in this area. This is a small but significant step forward for our economic relationship with an important trading partner, and will further the creation of a seamless Trans-Tasman business environment. Once again, I do thank the Australian Government for its cooperation and assistance in this endeavour, and I commend this bill to the House. Thank you.
Members, the question is that the motion be agreed to. I call the Honourable Clayton Cosgrove.
Mr. Speaker, I thank the